Again.
Yeah, so from the above definitions, it is very clear that for an agreement to exist, there must be the following. First of all, there must be popularity of persons. Let me hope you're all looking at your notes. You're referring to your notes as you're watching the video. Yes, there must be popularity of the persons. There must be two or more persons. Let me ask. Can Mr. Rich agree by himself? Will that be an agreement? Of course, no. Meaning that there has to be Mr. Rich and Sarah, for example. And they come up and they agree upon something. Yes. So an agreement has to be between two or more persons. It can't be made by one person. Then that won't be an agreement. Yes. And secondly, for an agreement to exist, there has to be consensus ad idem. Consensus ad idem is a Latin term that means meeting of the minds. For example, let me use the same names I used in the notes because you're following your notes right now. Yeah, for example, Mr. Rich owns 2 cars. One of the car is Japan made and the other car is Sudan locally made. Mr. Rich is selling the Japan car to Arab. Arab he believes that he's buying the Sudan locally made car. So the two parties, Mr. Rich thinks he believes actually he's selling to Mr. Japan, and he's selling to Mr. Arab the Japan made car, and Arab accepts the offer of selling him a car, thinking that he's buying the Sudan locally made car. There is no meeting of the minds. Both parties think totally different. So there is no consensus ad idem, meaning that there is no agreement. So for a contract to exist, for an agreement to be an agreement, for offer and acceptance to happen, there must be there must be 2 or more persons offering and accepting to each other, and secondly there has to be consensus ad idem. Yeah, scroll down. And secondly, the agreement should be enforceable by law. Some agreements are unenforceable by law. For example, basing on the Ugandan law, for example, any agreement whose value exceeds 25 currency points, it is unenforceable by law, because the law makes it mandatory that in case the agreement is in writing, it must be in case a contract its value exceeds 25 currency points, it shall be in writing, meaning that it is mandatory. So any agreement which is not in writing, it is unenforceable by law because it contradicts with the law. Yes. So let's look at the types of agreements briefly. What are the types of agreements? We have social agreements. Social agreements are social in nature and don't enjoy the benefits of the law, and parties don't intend to create any legal relationship. Yes, for example, a mother and the daughter. If the mother tells the daughter that you sleep, when you wake up I will give you food, that is a social agreement, and the daughter allows and goes and sleeps and wakes up and food is not yet ready. Can the daughter sue the mother for breach of contract? No, because it is a social agreement. The parties didn't intend to be legally binding. Their intention wasn't to contract. Yes, and the second type of agreement is the legal agreement. Now this is the agreement that creates a contract. For example, the example I've given you of Mr. Rich and Mr. Arab buying and selling to the contracting via a car sale agreement. Yes, so that leads to a contract. because both parties have intention to be legally bound by the terms, by the contract they enter into. Yes. And I'll give you an example. Look through your notes. For example, James invites Sarah to a dinner. Sarah accepts the invitation but doesn't show up. James cannot sue Sarah for damages. Why? Because it is a social agreement. And the other example I gave you is Emmanuel promises to sell his house to Atem for $5 million.